we had a call a little while ago about somebody trying to pursue a commercial contract that involved a $10,000 deposit, and $10,000 to our caller. And hey, that's a lot of money. But when it comes to litigation, $10,000 is not much money, and often does not justify litigation.
No, so there are certain cases where if the contract is good for you, it could be worth suing over that $10,000 deposit. Obviously I'd have to see the terms of the contract, but if we're talking, for instance, a real estate transaction where a buyer backed out of the deal, unless they had a good reason to back out of that deal under the contract, that money may have become hard, otherwise known as, it is now non-refundable. The one place you usually can get out of that is if there's a due diligence period for the buyer where they have a certain amount of time to inspect the property and determine if it's good enough for them. But, it really comes down to what did that contract say.
My advice to the caller was that you're not going to hire a lawyer to jump in and file a lawsuit, because that's going to be at least $10,000. But you might hire a lawyer to take a look at the contract and just give you a general idea as far as your case is concerned. Are you right? Are you wrong? Are you somewhere in the middle, in some kind of gray area? I also said that sometimes a commercial contract provides that the winner gets attorney's fees when they sue each other. So I don't know, is there ever a situation where you're going, hey, you can't afford to sue over $10,000 here, but guess what? If I sue on your behalf, I'll get you your $10,000. They're going to have to pay me my attorney's fees and court costs. Therefore, it's a reason for me to pursue this case for you.
Yeah, you read my mind, Tom. So the two things you look for in that situation, and I have, these calls every week. Number one, what are the legal merits of the refund of your deposit? Are you right or are you wrong? And usually it's not very much of a gray area. It's usually pretty black and white. And number two, do you get attorney's fees reimbursed? Because like you said, you could pay an attorney $10,000 to get you $10,000, and then you just, wasted your own time. And then number three, if there are attorney's fees, assess who you're suing. Are you going to be able to actually collect the attorney's fees and the judgment, or is this just a shell-less corporation who does nothing, and maybe this was their only deal, or maybe they only have one or two other deals and they have no assets in their corporation?
Yeah, great point, Caleb. Now, I know from experience that a lot of people think, oh, you sue somebody in the state of Florida, you're always going to get your attorney's fees, aren't you? But no, that's not the case. You do always get your court costs, but attorney's fees, you get them in at least a different couple ways. One would be the Florida statutes provides that in any type of this case, the winner's going to get attorney's fees. You know a perfect example of that one.
Right. Residential real estate contracts is a great one.
Yeah, so if you're ever in a residential landlord-tenant matter, no matter what, Florida statutes say the landlords and tenants are suing each other, the winner gets attorney's fees. I don't know quite what the thinking was there, maybe just to really encourage people to settle their cases.
Yeah, perhaps. I mean, those are in all of them. But you're right. There's two instances where you're going to get attorney's fees back in Florida, by contract or by statute. And, even if you get them back, a lot of people think, like you're saying, hey, I went to court and we won. Where's my money? It's not so easy. You have to do some work on the back end. The judge does not make them hand you a check that day. You have to collect it somehow if they don't voluntarily pay it. Oftentimes that means you have to find a bank account and garnish wages, or you have to find some real estate that's non-homestead and record a certified copy of your judgment and have it be a lien on the property. So
when the caller was telling me that there was a commercial contract involved, because I confirmed with the caller that there was a written contract that had been signed, most commercial contracts are going to provide for winner gets attorney's fees. I think that's pretty standard procedure.
yeah, most all of them do if an attorney drafted them.
So those are the two situations where you get attorney's fees when you're suing people here in the state of Florida. One is that Florida statutes say in any case that involves this matter, winner gets attorney's fees, or two, there's a written contract between the parties that say if we sue each other, the winner gets attorney's fees. We just talked about commercial contracts, but another good example about that is the FAR bar residential contract for the purchase and sale of real estate. Most 98% of contracts in the state of Florida are FAR bar contracts to buy and sell homes, and that contract provides if we're suing each other, winner gets attorney's fees.
That's right, and the attorney's fees provision is actually a little bit of a gray one, Tom. There's something called case law out there where judges make decisions and we go off what they decided in the past. And courts have decided that attorney's fees provisions, who is the prevailing party, is really an interpretation, and that means who prevailed on the most substantial amount of issues. So there are cases where you may win your case, and because you lost on other issues in the case, you may still not be entitled to recovery of attorney's fees.
Okay, so you're saying sometimes in lawsuits there are many different issues, different parts of complaints, different parts to damages, and it's not, you don't necessarily win them all. Sometimes you just win some of them.
That's right. You could sue for 10 different things, and you win one of them, and great. You win $100,000 on one of them, and the court may say, well, you lost on all 9 other issues, so you don't get attorney's fees back.
Okay. So then we get to the next issue, which you brought up, and that is this. Well, first of all, let's give the phone numbers out again. Hey, folks, we'd love to get your legal question answered right now. All you have to do is call us right now at 844-580-9326. We'd love to get your legal question right now here at WDBO. Call 844-580-9326. Caleb, I don't know if I've ever asked you this question, but do you help people collect on judgments? Because it's hard work and often not successful work. Do you help people with that?
I do, Tom. Usually you start off with a little bit of discovery. So say you have a judgment now, and you say, what the heck do I do with this? Well, you got to discover the person's assets that you have the judgment against. Do they have real estate? Do they have bank accounts? If it's a corporation or LLC, get their accountants or their officers in a deposition and figure out where their bank accounts are, where their assets are. And then with that information, you can use it to try to lien those assets or garnish those bank accounts.
Caleb, I often have people come to me and say, Tom, I want to have I want to do a trust so that people can't get to my money. And I say, okay, if they sue you, if somebody sues you and they get a judgment against you, they're going to serve a paper on this that says here's a list of, I'm going to take your deposition, just like you're talking about. I'm going to try and discover what you own. Here's a 2 or 3 page list, single page list of everything that you have to bring with you, and including copies of any trust wherein you're a beneficiary or grantor.
That's right, Tom. That's one of the ways we do it.
So there may not be anything in the public records about this trust, but when they take your deposition, you're required to bring copies of it, copies of bank statements, copies of tax returns, you name it. It's a long and lengthy list.
And correct me if I'm wrong, Tom, but my understanding is that as far as trust monies goes, a creditor can't touch money in trust, but they can touch any money that's being dispersed from the trust once it's dispersed.
I would disagree with that. So
Okay.
the typical revocable living trust that I do for people, when you hear about people talking about trusts out there, they're talking about the same thing, a revocable living trust. People are using them for the purpose of avoiding probate. A typical revocable living trust has nothing to do with protecting your assets from the creditor claims. Any creditor that gets your money without a trust can get your money with a trust. Now, if mom and dad created a trust that says when we die, we're going to leave $1 million, it's going to stay in trust, and my trustee is to give my daughter as much money as she needs for health, education, support, and maintenance, and the daughter is sued for $1 million, that creditor cannot go to mom and dad's trust because that money is not the daughter's. Mm-hmm. She's only entitled to as much as the trustee wants to give her that she needs. And so then the minute the trustee writes her a check and says, yeah, you need $10,000 for a new car, and as soon as they write that check to the daughter, if the daughter's creditor was standing by, they could grab that $10,000.
Exactly.
That's what I think you might be saying.
That's what I meant. You said it much more elegantly.
Yeah. So the thing about collecting on a judgment, if you're a lawyer trying to collect on a judgment, you may take their deposition today, and they may bring stuff to you, and it's, I don't see much here, nothing here for me that I'm going to be able to go after, and you drop the case. Whoever holds that judgment, they may say, I guess I lost, I'm going to give up forever, but really, judgments are good for 20 years in the state of Florida.
So they have a lot of time.
They could drop it, and 5 years later come back and try and take your deposition again and try and collect it and see if circumstances have changed.
The easiest way, Tom, is once you get this judgment, just record a certified copy, and then it acts as a lien against real property for about, I think the time frame is 10 years. And sometimes you get lucky. I just had a client who got lucky. I recorded that judgment, and turns out the person we had the judgment against was selling some property, and we got paid for it.
that was your lucky day.
That was
Your
Doesn't
client's
always
lucky
happen.
day. So when you get a judgment against somebody, and let's say you get that judgment in Orange County, yeah, sure, recorded in Orange County, that is more than likely where the defendant owns property if they live in Orange County. But that covers real estate in Orange County.
Correct.
There are
Doesn't cover any other counties.
A little bit of trivia, Caleb. How many counties are there in the state of Florida?
Ooh, I couldn't even guess.
67.
Oh my goodness.
Okay. So in theory, you might have to record it in all those counties. Hey, folks, my